Good morning, friends. This is Suresh, your commerce teacher from Government Degree College, Kukatpalli. Today, we will learn the essentials of an offer. I mean, the essential elements of valid offer. I told you in my previous class that one of the essential elements determining the validity of contract is lawful offer. For a layman, offer is a mere proposal made to execute a particular transaction, but it has got indispensable significance in the literature of law as the concept legality depends on many independent and interrelated factors. So today we will understand the legal definition of offer, the classification of offer, the essential elements or legal rules of offer. These three topics will cover the discussion on offer. Offer is of paramount importance in the literature of Indian Contract Act because offer is the genesis of forming any contract. It is the offer which determines the terms and conditions of a contract. It is the offer which ultimately binds the parties into contractual relationship. I mean, there are two parties in a contract of whom one is called an offerer and another is called offeree. The person making offer is called an offerer and to whom it is made is called an offeree. So let us now understand the legal definition of offer given in Indian Contract Act 1872. According to Section 2, subsection A of Indian Contract Act 1872, when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence is called an offer or proposal. Right? So, this is the formal definition given in section 2, subsection A. Please do remember that offer and proposal mean the same as far as legal diction is concerned. Here in this definition, you can see two facets. That is, one person can make an offer either to do a particular work or to abstain from doing a particular work. We all know that we make offer to do a particular work or to execute a business transaction. What is this? Why should we make an offer to abstain from doing anything? That is, refraining ourselves from doing anything. Does it require an offer? Yes. Sometimes it also requires an offer. Let me take an example to illustrate it. For example, I may propose to my friend, give me 1 crore rupees of goodwill. I will not enter into your locality and I will not come into competition with you in business. That means I will abstain myself from doing business in your locality if you give me some consideration, some amount. So it is also a valid offer, right? Of course, sometimes it may lead to formation of syndicates and in some occasions it is forbidden by law. That is different thing. But only for the purpose of understanding, do remember that we can make offer sometimes also to refrain ourselves from doing a particular work, right? So this is the formal definition of the word offer. I repeat, when one person, that is offerer, signifies to another, who is that another here? He is offeree, his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other. Yes, we make offer in order to obtain the acceptance of the offeree. Here that other means offeree, right? So this is the legal definition for the word offer. Now let us see the types of offers. How many types of offers we do come across in our day-to-day life, and how many of them will bind the parties with contractual relation. Hope you understood the definition of offer. Offer can be made either to do or to abstain from doing a particular work or activity, right? Now let us straight away go to the classification of offer. We can classify offer into 5 categories, namely general offer, special offer, cross offers, counter offer, and tender. Tender we can again bifurcate into standing and specific tenders. Let us see one by one in detail. General offer. The name itself indicates that an offer made to public at large is called a general offer, to which anyone can give their consent either through implied actions or with expressed assent. That is called a general offer. It is valid in the eyes of law to bind parties with contractual relation. Let us take an example. If a company makes an offer in the paper, anyone finding defects in our product will be rewarded with rupees 10,000. Here the term anyone means it's a general offer. It can be you, I, or someone else. So can take this challenge, find defects, and bind ourselves into contractual relations. So offer made to public at large is called a general offer. It is very much valid. Second, we have special offer. Obviously, an offer made to a specific person or a specific offeree is called special offer, to which others cannot give their acceptance. Third, we have cross offers. I am using the word offers, plural. So, when two identical offers are exchanged between the parties in ignorance, the offers are said to be crossed. Confused? Let me take an example. Suppose Mr. A writes a letter to Mr. B. Mr. B, will you purchase my house for rupees 1 crore? B is not aware of this letter. B also wrote a same letter or same kind of letter to Mr. A. Mr. A, will you sell your house for rupees 1 crore? So if you see these two letters, the content is same. Mr. A says, will you purchase? Mr. B says, will you sell? So there is no question of saying, yes, I will purchase. That means it is not binding the parties with acceptance. So the content of both the offers moved from A and B are same. Therefore, these two offers are said to be cross offers. Next, we have counter offer. If one offer is encountered with another offer, it is called a counter offer. We can also take it another way. If one offer is subjected to conditional acceptance, it is a counter offer. We need to have unconditional acceptance. If acceptance is subjected to conditions, it is a counter offer. Let us take a small example. I wrote a letter to my friend, Mr. A, will you purchase my house in Hyderabad for rupees 1 crore? He replied me, yes, I will purchase your house in Hyderabad for 1 crore, provided you purchase my shop in Delhi for 10 crores. So he is not saying unconditionally, yes, I will purchase. Rather, he is imposing a condition. If you buy my shop in Delhi, I will buy your house in Hyderabad. So he is encountering my offer with another one. So it is a counter offer. So cross offers and counter offers will not create any contract. They are invalid in the eyes of law. Next, we have tender. Tender is also an offer, but it is an offer made in response to the invitation to offer. What is this? Let us suppose a local authority or a municipal body want to construct a road or a bridge. It gives an invitation in the newspaper. we want to construct a road or a bridge. These are the specifications. Interested parties may submit their offers in the form of tenders. So we will see who is submitting at the lowest price, to which we will give our acceptance, right? So we are inviting you to submit your offers. That is called tender. So simply remember that tender is also an offer submitted in response to the invitation to offer. Tenders are of two types, standing tender and specific tender. Standing tender is time bound. Let us suppose tender invited for supply of raw material continuously for 1 year. So that is called a standing tender. Special tender, it's for a specific work. Once the work is executed, then contract ceases to exist. That is called a special tender. So among these 5 categories, only general offer, special offer and tenders are valid. They will create contract but not cross offers and counter offers. Why? Why cross offers and counter offers cannot create valid contract? Because they will not fulfill the legal rules with respect to the valid offer. So obviously a question sprouts in your mind, what are those legal rules creating or granting validity to offer? That is our next topic, that is legal rules of valid offer, right? Now, I divide legal rules of offer into 10 essential elements. The first one is it must be capable of creating legal relationship. Here, legal relationship means the relationship of promisor and promisee. It should subsume all your personal relations as far as contract is concerned. Let us take an example, Balfour versus Balfour. What happened in this case is there was an agreement between wife and husband such that husband will pay monthly maintenance to his wife if she lives separately. But he failed to keep his promise. The dispute was challenged on the grounds of law. It was held in the court that the agreement between wife and husband is invalid because wife and husband's relation is a social relation and not a legal relation. If such agreement has to be animated, it must have been done through legal divorce or formal separation. So, mere social relation of wife and husband cannot bind them into contractual obligation. Second, it must be definite. That means the terms of the offer must be clearly defined. There should not be any ambiguity or confusion with respect to the content of the offer. Third, it may be general or special. As I told you that general offer is also a valid offer. Let us take a small case law, very famous case law rather, to illustrate it. Carlyle versus Carbolic Smoke Ball Limited. In this case, one company announced in the paper that anyone using our smoke ball products and getting influenza will be compensated with 100 pounds. One lady, Carlyle, has seen the ad, that is advertisement, and used the product as per the terms and stipulations laid down by the company. But still, she got influenza. She made a claim for the promised sum, but the company rejected to pay that she did not sign any agreement accepting the terms. So the dispute was challenged in court. It was held that the offer made by company in paper is a general offer to which either Carlyle or anyone can give acceptance through their implied actions. Therefore, company is liable to pay compensation for the victim. Next, fourth, it must be communicated to offeree. Offer must be communicated to offeree. The communication is of quintessence in determining the contractual relationship between the parties. There is again a famous case law that took place in 1913, that is Lalman Shukla versus Gauri Datta. In this case, Gauri Datta was a master and Lalman Shukla was a servant. One day, the nephew of master absconded from the home, and the master directed Lalman Shukla to go and search the missing nephew. He was on the task. Meanwhile, Gauri Dutt gave an advertisement in the paper. Anyone tracing the missing nephew will be rewarded with rupees 500. Don't laugh, rupees 500 was very handsome sum back then in 1913. So this advertisement was unknown to Mr. Lalman Shukla. But he succeeded in tracing the missing nephew and bringing him back home. There ended the matter for time being. But later on, he came to know that there was an advertisement in the paper that whoever traces the missing nephew will be rewarded. He went to his master and demanded the money, and the master rejected to pay the same. Dispute went to court. It was held that whatever the task executed by Lalman Shukla was as a consequence of master and servant relation and not that of offerer and offeree. Because the advertisement was not communicated to Lalman Shukla before he began his search operation. Had it communicated to Mr. Lalman Shukla and then started operation, he would be entitled for compensation. But for that, he is not entitled to get any compensation because the servant and master relation cannot subsume the relation of offer and offeree and vice versa unless the terms of offer or the offer is clearly communicated to offeree before he started working on that. Right? So offer must be clearly communicated. Now, let us see the fifth point. Well, offer can be conditional, but such conditions should be communicated along with the offer. Please do remember that offer can be conditional, but acceptance must be unconditional. What happens if you keep conditions in the acceptance? It will lead to counter offer. So if you want to keep conditions in the offer, it must be duly communicated to offeree, or at least there must be something that attracts offeree towards the terms and conditions, or there must be something that implies that there are terms and conditions in the offer which offeree must clearly understand. Let us take case 2 illustrated further. Parker versus Southeast Railway Company. In this case, one person, Mr. Parker, went to a railway clock room and deposited his baggage in it, obtained an acknowledgement, that is a ticket. So, on the front of ticket, that is acknowledgement, there was one condition. See backside for terms and conditions. Mr. Parker ignored it. So, there was a condition backside that railway company is responsible only for 10 pounds if the baggage is lost. So, unfortunately, the baggage was lost. Parker claimed 50 pounds, but the company paid only 10 pounds. Dispute went to court. So it was held that Parker is liable to read the conditions because there was something to attract the attention of Mr. Parker on the face of ticket. See backside for terms and conditions. So conditions are deemed to have communicated to offeree, that is Mr. Parker. So Parker cannot claim more than 10 pounds as laid down in the condition. I have one more interesting case law to tell, but I don't have it in slide here. Ole versus Malbrook Hotels Limited. One person, Ole, wanted to hire a hotel room. He paid advance, signed on the check-in register, entered the room. So after entering the room, he found that management is not responsible for the loss of baggage. He ignored it, held that Mr. Ole need not to abide by those conditions because those conditions are communicated to him only after signing the agreement, that is only after signing the check-in register. So he need not to abide by those conditions. Sixth one, mere price declaration is not an offer, please. So again a famous case law, a hallmark case law rather, Harvey versus Fassey. In this case, one fellow Harvey had a habit of collecting antique pieces. So he came to know that one person, Fassey, owns an antique piece called Bumper Hall pen. He wanted to acquire that. So he made a telegram to Mr. Fassey. Will you sell your Bumper Hall pen? Please quote the lowest price. A reply came from Fassey. The lowest price is £850. Then third telegram from Harvey to Fassey. 850 pounds is okay for me and acceptable for me. Let us finalize the deal. Fassi rejected to sell the goods. Dispute went to court. I made an offer. He quoted the price. Offer plus acceptance is equal to agreement. Now he is revoking the agreement. So it was held in the judgment that there was no agreement because mere price declaration is not an offer, right? So remember, in this case, there were three telegrammic conversations. One, the first telegram says, will you sell your bumper hall pen? The second question is, quote the lowest price. So reply came only for second question, that is lowest price. He did not answer whether he will sell the pen or not. So mere declaration of price is not an offer. Please be mindful with the fact that if you go to a supermarket, pick up the goods and it is not an offer, please. So declaration of price in the supermarket or display of goods in the supermarket shelf is not an offer. Rather, it is invitation to offer. So it is you, that is customer, who should pick up the goods and go to counter and make offer. So if he is willing to sell, he will give invoice for that, right? So mere declaration of price is not an offer. Similarly, offer must be distinguished from an invitation to offer. I am sorry for the typing error. It is not top, it is to. So earlier I told you that when we make invitation to offer, the response comes in the form of tender, that is offer. So invitation to offer is different from general offer. So offer should not contain a term that non-compliance leads to acceptance. What is this non-compliance leads to acceptance? Let us take an example. Suppose I wrote a letter to my friend, Mr. X, will you purchase my house? Please give your reply within 15 days. If I don't get any reply within 15 days, I will assume that you are accepting my offer. That means if you don't comply with my offer, I will assume that you are accepting my offer. Is it not stupid? Yes, certainly. So, non-compliance leads to acceptance is an invalid term, is an invalid condition. It should not be there. Therefore, we say that offer should not contain a term that non-compliance by the offeree leads to acceptance. If such condition is there, it is invalid in the eyes of law. Next one, the offer must be made with an intention of abiding by it. Obviously, I cannot make offer without intention of abiding by it. Suppose I made an offer to a builder to construct a house. He gave his acceptance, sought some time, went to his village, bought the labor, material and everything. And when he was ready to execute the contract, I simply said, no, I was cutting a joke. I was kidding you. I don't have any intention of giving contract to you. Will he keep quiet? Certainly not. So, once you make a formal offer, you must have an intention of abiding by it. Otherwise, it will lead to breach of agreement. Finally, offer must be lawful. Naturally, you cannot make offer to execute any forbidden activity or prohibited activity. So, these are the 10 essential elements of lawful offer, right? So, with this, offer, the terminology of definition comes to conclusion. Now let us write an assignment on offer. Our next class will be on acceptance. So I'll give you 2 questions in assignment. They are of very much importance to your examination. So please do attempt these 2 questions. Define the term offer and explain the essential elements of valid offer. Second assignment is bring out the classification of offer, right? I hope these 2 topics were duly covered in this discussion. So see you in the next class. If you have any doubts, please feel free to revert back at 98495 60102 or nsureshnaidu@gmail.com. That's all for now. Have a nice day. See you in the next class. Bye.